So here's a question. The Supreme Court has two kinds of jurisdiction, original and appellate. As we have now discussed several times, the Supreme Court's original jurisdiction is limited to a very narrow class of cases. So in most cases, the Supreme Court's jurisdiction is appellate. The Supreme Court was envisioned by the founders as being an appellate, primarily an appellate court. They wanted the Supreme Court, the founders wanted the Supreme Court evaluating lower court decisions for legal error. To be clear about the structure of the court system, in the federal court system we have U.S. district courts, which are trial courts. Fact-finding goes on in trial courts. Appellate courts are checking for legal error. Appellate courts, generally speaking, are not there to decide who done it. So, again, the founders envisioned the Supreme Court as being an appellate court, not a court where essentially the justices are sitting there as jurors finding facts, but where the justices are there to correct legal error below. In the federal system, you have the district court, that's the finder of fact. You have the Federal Court of Appeals, the U.S. Court of Appeals, also known as Circuit Court, right? There are 13 different circuits around the country, which don't bind one another. I hope you've covered that in Civ Pro. I'll ask you that when we have a live session, or some other course. And then you have the Supreme Court at the top, the Supreme Court envisioned as an appellate court. Now the question is, where are those appeals going to come from? The structure of the Constitution, Article 3, clearly anticipates that the Supreme Court is going to have very limited original jurisdiction, and in most cases is going to have appellate jurisdiction. But let me repeat, where are those appeals going to be coming from? Okay, that question sets up Martin versus Hunter's Lessee, which is our next big case, another very famous case in constitutional law. This case comes to us from Virginia, and what looks at first like a common land dispute turns into a major constitutional issue. First of all, Justice Marshall should have recused himself in Marbury versus Madison. We find out in Martin versus Hunter's Lessee that he actually does know how to recuse himself, because he did recuse himself in this case. In this case, he had a financial interest in the outcome of the case, so he did not take part in the decision. At least he didn't formally take part in the decision. There's really no question who was running the Supreme Court at the time, and that actually is important. The reason that's important is that this involves two courts, primarily, the U.S. Supreme Court and the Court of Appeals of Virginia. And the Court of Appeals of Virginia at the time was the highest court in the state of Virginia. So basically, the Court of Appeals of Virginia, let's just call it the Virginia Supreme Court, because that's what it really was at the time. The chief judge of the Virginia, essentially Supreme Court, was somebody named Spencer Rowan, R-O-A-N-E, who is relatively famous in the early part of our country's history. Judge Rowan was political enemies with John Marshall, who of course then was the Chief Justice of the U.S. Supreme Court. John Marshall, obviously, the author of Marbury versus Madison, had a pretty expansive view of the power of the federal judiciary. That certainly suited him, since he's the Chief Justice of the U.S. Supreme Court. Judge Rowan, on the other hand, has a very narrow view of the power of the federal government in general and the federal judiciary in particular. So here's what happens. We have a land dispute. Martin and Hunter, well, shorthanded as Martin and Hunter. Martin is the Brit, and Hunter is somebody whose claim to the land rests on Virginia law. Let's talk about what's going on here. So Martin, a British subject, has a claim to this land. Martin's claim to the land arises under a federal treaty, because the way wars ended, this sounds quaint anymore, but the way wars used to end was that the parties agreed, and they'd usually exchange promises, give a little here and there, right, and agree to end the war. We had a treaty with Great Britain, and the treaty with Great Britain said that one of the things we were going to do to end hostilities was return, this kind of paradigm keeps showing up, return property to British subjects whose land had been taken. So Martin claims under a U.S. treaty. Okay, Hunter claims the land, to repeat, under a Virginia statute, under Virginia law. This then implicates the Supremacy Clause of the Constitution. That clause, whether you're looking in your pocket copy of the Constitution or in your casebook, wherever, that clause is in Article 6 of the U.S. Constitution, and it reads like this. This Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state, to catch these words, the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding. Woo, 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 a bunch of syllables. 3 different items are identified here as the supreme law of the land. The U.S. Constitution is one, statutes passed by Congress is the second, and notice the third, treaties enacted under the Constitution. Those 3 things are sources of federal law that constitute the supreme law of the land. Again, that's why this is called the Supremacy Clause. And if there's a conflict between those sources of law and any state law, federal law trumps, no pun intended, federal law trumps state law, assuming the federal law is valid, it trumps state law. And to boot, the Supremacy Clause itself says that even judges in the states, state judges, are bound to follow the federal Constitution, federal statutes, and federal treaties when those things conflict with state law. That, by the way, we'll come back to this later, is called preemption. Please know that word. Federal law preempts state law where there is a conflict between the two. So again, let's look how this sets up in Martin versus Hunter's Lessee. One more time. Martin is claiming under a federal treaty. Hunter is claiming under Virginia statute. Under the Supremacy Clause, then, I'll pause here and ask you which one wins. Okay? Think about it for a minute. Good. You should have said Martin. Martin wins because Martin claims under a treaty, and under the Supremacy Clause in Article 6 of the Constitution. Okay, I'll pick up where I left off with Article 6 of the Constitution, if I can remember that. I just have to interject here. This has been a heck of a day with this dog. She's basically got 3 things she wants to do. Play, drink water, run around, bark, or get in my face. So you now have seen all of that. So my apologies. Keep having to stop and start again. So you should have said Martin wins under Article 6 of the Constitution, the Supremacy Clause, which says that a treaty trumps a mere state law. And if Hunter's claiming under state law and Martin's claiming under the treaty, Martin wins. So, interestingly, the Virginia trial court gets this right. The Virginia trial judge said, well, you got a treaty that says Martin gets it, you got a state law that says Hunter gets it. The Supremacy Clause says I, a state judge, have to honor the treaty over the state law. That's what I'm going to do, and I award the win to Martin. Now, of course, what happens in cases is that whoever loses has a right to appeal. That's an important constitutional principle. We'll cover more throughout Constitutional Law 1 and 2. If you lose in a trial court, you are entitled to due process under the 5th and 14th Amendments to the U.S. Constitution. You don't have to know this right now. I'm just throwing it out there as what's going on, right? Both of those amendments require due process, and the Supreme Court has said that as a matter of due process, which means fundamental fairness, you are entitled to at least one appeal. I should say only one appeal, but at least one appeal. You're entitled to that as a matter of constitutional law, because it's not fair. It's not fundamentally fair to leave you stuck with a lower court decision where error, in all likelihood some error did occur, and outcome determinative error might have occurred. So you're entitled to one appeal. So Hunter lost, Hunter appeals. Hunter appeals to the Virginia Court of Appeals, which again is sort of the Virginia Supreme Court at the time. And Judge Rowan has no use at all for a federal treaty, especially vis-a-vis a Virginia state law. So the Virginia Court of Appeals reverses the trial court. I'm going to pause here and talk about the difference between overrule and reverse, because I always do this every term. I don't want to stop doing it just because we're not meeting in person. If we were meeting in person, I'd write these 2 words on the board, so I'll put a slide up. There's a difference between reverse and overrule. Reversing is what a higher court does to a lower court in the same case. I'm going to go through this pretty fast because you have a chance to pause and rewind here, so I don't have to say it over and over again, because I usually do in class. Reversing is what a court does, a higher court does to a lower court in the same case. same parties. They may switch, from one side of the V to the other as they go up the line in the appellate ladder, but a higher court reverses a lower court. Overruling is what a court does to a prior decision reached in a different case. So, for example, Brown versus Board of Education overruled Plessy versus Ferguson, two famous cases. Brown versus Board of Education didn't reverse Plessy versus Ferguson because it can't, because Plessy versus Ferguson is already done, right? That case is over. So reversing is what you do in the same case to a lower court in the appellate ladder with the same party, same issues coming up through the appellate chain, if you will, and that's called a reversal. When you're getting rid of a prior decision in a completely different case, that's called overruling. We're getting rid of a prior legal principle.